Today, we're going to be going over the offer to purchase and contract. Sometimes you may hear this referred to as standard form 2T. If you're taking the test, don't worry about that. The fact of the matter is they'll never require you to memorize the name of a form, but it's the offer to purchase and contract. For pre-licensed class, one of the things that you may want to take into consideration is as you're looking at these contracts, always ask yourself, who are the parties to this contract? Well, this is an offer to purchase. So this is between the buyer and the seller. And once the buyer makes an offer or the seller a counter offer, and then the other party accepts it, it becomes a contract. So it's one form that serves two purposes, starts out as an offer, hopefully ends up in a contract. So then we get into the meat of it and it starts talking about what's going on. The first part of it is just the preamble. It just kind of tells you what's getting ready to go on. The buyer offers to purchase this property and the seller agrees under these terms to sell the property. One thing I'd like to point out to you in the preamble is anytime you see a word at the end of that first paragraph there, you see the word contract and it's capitalized and in quotations for no apparent reason. This is what we refer to as a defined term. If you would look back just before that, you would see that they define what the contract means. Look for that several times throughout these defined terms. I'll show you a couple more in just a second, and then throughout the form, if you'll remember to look for that. So now we're going to introduce the parties, the terms and definitions here. Notice that we're introducing the seller and the buyer. Do you see again, seller capitalized in quotation, buyer capitalized quotation, property, same thing. What that means is we've defined those terms, and every time you see them in the rest of this contract, they mean what they say right here. So notice how I put the seller's name in here. Seller was Chris R. Barnett and Lisa H. Barnett. I used some of our information in this because the fact of the matter is it's public information anyway. So I don't mind using my own information in here. What I would like for you to do for the seller is to be as specific legally as is necessary. I've had some attorneys who were so paranoid that what they say is write out the whole name, Christopher Randolph Barnett and Lisa Harrelson Barnett, married. Now, we've identified the two parties to the contract, and then you can see the same thing that we did on the buyer side. John J. Doe, could be John James Doe if you want to do that, and Jane Russo Doe or whatever on that. Notice that I also identified that they were a married couple as well. This is not required by law. It's suggested in the guidelines for this form. And basically what it's doing is it's sending a note to the attorney to let them know these are married parties here. We're going to need two signatures. There might be some other legal things that come in about how the buyer can hold title. Remember when we were going over this in pre-license class and we talked about the idea a married couple acquiring property in North Carolina while married would automatically own the property as tenants by the entirety. So even though this is not required by law, it sends a signal to the attorney that they're dealing with married couples and they can act on that cue. Now we're going to define the property. And to give you a brief version of this, and I would like for you to read this so that you're familiar with what it says, but my opinion on property is the more information, the better. So in other words, notice how the property description starts out. It starts out as being 208 Highland Springs Lane, Holly Springs, 27540 in Wake County. And that's certainly our mailing address. The problem is never use just the mailing address when you're conveying real property. Try to get more information. That way, if you've made a mistake, a typo with the address or something like that, you haven't misidentified the property. So if we take that legal description, and in class, we talked about this as well, and hopefully in the field, you're being trained by your mentors on this, where you can find these plat references. And notice what mine says here, lot 314, phase 3, Holly Glen subdivision. It was on a book in 1998 on page 288. That's where if you wanted to actually see it, you could go take a look at the plat that shows where this property is. But you know what? My property also had a PIN number. Most properties do. It's a property identification number. It's a tax type description. So I added that on here as well. And then finally, I even put the deed reference on here, deed book 11028, page 1049. So between those three pieces of information, it gives you an unambiguous idea of where this property is located. Should be no mistakes in regards to that. I do want to take you back one more time and show you how we define the property. Okay, remember, capital P property always means this. The property shall include all real estate described below, and you've just seen the legal description, with all appurtenances thereto, including the improvements located thereon and the fixtures and personal property listed in paragraphs 2 and 3 below. So later on, when we see paragraphs 2 and 3 below, these fixtures and personal property that have been included will automatically be part of the property. If it says that the property will convey or the property this or that, it's referring to all of that. That'll help you with the reading of the contract and those defined terms. Okay, then we get into the purchase price. Now the buyer's telling how they want to buy this particular property. They're going to pay $400,000 in US dollars. That's stipulated by the contract. If you're going to do something other than US dollars, you would need to modify this or have your own contract written. All right, I need to slow down right here for just a moment. At this point, I can't give you a ton of ideas about how much due diligence should be. It's going to be dependent upon the market that you are in. There are some markets in North Carolina that probably put down somewhere between $0 and $250 in due diligence fee. At the time of this recording, I'm in the Triangle, North Carolina, and due diligence fees have been $20,000, $50,000, some cases $100,000. So it's very important for you to understand when your client is signing this, what it is that they have at risk. So the due diligence fee, we're going to describe that on the next page. But for right now, I'm going to say that this is a fee that has been put up to tie the property up for a period of time so that the buyer can do whatever diligence they want to. It is non-refundable, guys. Okay, so the due diligence fee is non-refundable. Now, notice also after we ask for the due diligence fee, here's the other important part of this. The due diligence fees are actually made out to the seller. This is money going directly from the buyer to the seller. Why don't we put it in escrow? Well, because the due diligence fee has been earned by the seller the minute you go under contract. As a matter of fact, let me show you one of those other defined terms that we talked about. Notice that the fee is to be delivered to the seller by the effective date, capital E, capital D, effective date. You'll see that on the next page as well, or next couple of pages. And then we tell how it's going to be delivered, in this case by official bank check. Now, as I was saying with the due diligence fee, make sure your buyers understand that once they go under contract, they are forfeiting this due diligence fee to the seller. Now, they will get credit for it at closing if they do close on the property. But if they walk away for any reason or no reason at all, they will lose that due diligence fee. If it's $0 to $250, that's one thing. But if it's $20, $50, or $100,000, that's a big deal. And buyers need to be aware of the repercussions of this. Okay, and then $20,000 in an initial earnest money on this. Again, I'm not advising you how much it should be. I'm just putting in a placeholder in this particular case. The initial earnest money, notice that it'll give you a couple of options here as you get to the end of the paragraph. It can be delivered on the effective date or within 5 days. I highly recommend that you give your buyer, a little bit of time to put the earnest money together. And the earnest money is actually going to be made to typically a trust account or an attorney's trust account. So here it just describes the situation. If you plan on putting up initial earnest money deposit, how is it going to be paid and when is it going to be paid? When we talk about additional earnest money deposit, that's actually, we're getting into strategy at this point. In the field, you'll get trained on when it might be appropriate to do additional earnest money versus initial earnest money, or both for that matter. But for right now, there is one thing I would like for you to take a look at. If you do offer additional earnest money, please notice two things about this. One is that additional earnest money is always time is of the essence, which means if I put a date in there, August 25th, okay, if I put August 25th on there, then I must have delivered that additional earnest money by August 25th at 5 o'clock. If not, I've waived my rights associated with it and could in fact be in breach of contract. And then notice also how the additional earnest money must be delivered. Cash, official bank check, or wire transfer, or electronic transfer, not your check. And the reason for this is additional earnest money often comes up late in the game. And so an actual check might not have time to clear before closing. Trust me, in the field, you'll need to get advice on strategies around additional earnest monies and when it's appropriate. It's not always necessary. These next few are rarely used. By assumption, if a buyer is buying the home and assuming a loan, we have a form for that. If a buyer is buying a property where there's seller financing, we have a form for that. You would just add that as well. And then if they're buying a new home using this form, we have additional addenda for that as well. One technical point on this, please notice that the purchase price of 400,000, what you would do is you would take the 400,000, you would subtract the credits that the buyer is getting, 20,000 for DD, 20,000 for initial earnest money. If there was anything in these other blanks as well, you would subtract that. In this case, there is not. So 400 minus $40,000 is $360,000. That's the balance that the buyer is responsible for at settlement. Now, granted, some of it might be coming from a bank, but that's how much the buyer needs to come to closing with between themselves and their lending institution. Okay. The paragraph on the bottom of this, not a big deal, except from this standpoint. If you plan on having wire transfers, then the seller needs to work with the buyer on this. In other words, they'd have to give them account information to wire the funds to. Some sellers are hesitant on that. So you'll need to work with the bank and the buyer and the seller to make sure this comes out together, or just don't do a wire transfer if the seller is going to be uncooperative. This next paragraph right here is actually very, very tough, but it's kind of important. It's especially important in the field. And what this says is that the due diligence fee and the initial earnest money date are due by certain dates. Okay. Now, if they are not paid by those certain dates, or if the buyer wrote a bad check or something to that effect, this paragraph right here describes the remedy from the seller. So if the seller doesn't receive the due diligence funds at the appropriate time, or the initial earnest money, or if they receive a bad check, then what the seller, probably the seller's agent, realistically needs to do is they need to give written notice to the buyer or the buyer's agent and say, you need to make this right within one banking day. This is the only place in this contract where it mentions anything other than a calendar day. So let's take a look at what that would look like. Let's say we go under contract today. As I'm talking to you today, it's Friday. All right. So if we go under contract today, the buyer has until the end of today, the effective date of the contract, to get the due diligence money in the seller's hands. Well, if for some reason the buyer doesn't do that, the seller wakes up on Saturday morning and says, hey, I don't have the due diligence money. I was supposed to have that on the effective date of the contract, and I don't have it. What can I do? Well, what the seller can do is they can make a written demand for the money, and then they give the buyer one banking day to repair this breach. In essence, the buyer is in breach, but they're still under contract. One common mistake that agents make is they think if they don't have the due diligence money in hand by the effective date, that they're not under contract. That is absolutely not true. Absolutely not true. You're still under contract. The buyer just happens to be in breach. But here's what the remedy for that breach is. If the buyer can get you the due diligence fee in good money, in other words, they would have to give it in cash, official bank check, wire transfer, electronic transfer. Again, I'm not accepting your check at this point. It would need to be in one of these particular manners. If the buyer can do that by the end of the next banking day. Now, let me remind you, at the time that I'm delivering this particular presentation, I told you it was a Friday. So when would the next banking day be? It's not going to be Sunday. It's going to be Monday by the end of business, which traditionally has been around 5 o'clock. If the buyer is able to make good on that due diligence, then they're fine. They're back in under the terms of the contract. But if they can't, by 5 o'clock on Monday, then what the seller could do at 5:01 is the seller could actually terminate this contract, and then they could go sell the property to somebody else. It's very rare that a seller has a right to terminate the contract, but this is one of the rare conditions that a seller would have that. If they gave written notice, waited one banking day, and the buyer could still not fulfill his obligation to deliver the due diligence fee or the earnest money, if that's the problem, then the seller could terminate after that one banking day and go sell the property to somebody else. In regards to earnest money in the next paragraph, it talks about where it's going to be deposited here. You can see that I put in the name of an attorney that we use on a regular basis, because it's not that uncommon today for a lot of firms do not have trust accounts any longer. And because of that, they will usually allow an attorney to hold the escrow. So what's going to go where it says the escrow agent, if in fact it's the listing firm, then you would just simply put the listing firm's trust account there. In this case, it just happens to be an attorney. So we put the attorney's name there as well. I would point you to this box. And historically, this has been a great place for the commission to ask test questions. I don't know if they ask test questions on it quite as much because it's a rarity these days. And what it talks about is, what if there's a dispute regarding earnest monies? Well, there are very few disputes today about earnest money, and let me explain why. Because whether you're alive or whether you're in the field or whether you're taking the test, this is going to be important to you. The reason there are very few disputes regarding earnest money today is the due diligence has taken these disputes away. For suffice it right now, and I'll explain the due diligence further in just a moment, but suffice it to say right now, if the buyer walks away during the due diligence period, they lose their due diligence, but they lost that on day one, okay? Unless they close, they get credit for it. But if they close during the due diligence period, the contract clearly says that they get the earnest money back. The buyer can walk away after the due diligence period. A lot of agents are confused about this, but the fact of the matter is a buyer can walk away anytime they want to. The only difference is the penalty changes. So if the buyer walks away from the contract for no apparent reason after the due diligence period, then they would lose not only their due diligence money, but also their earnest money as well. And because the contract is so specific on this, there should not be disputes regarding earnest money any longer. Having said that, human nature being what it is, there will always be disputes. So let me tell you how they used to test this in North Carolina. In the event of a dispute in regards to earnest money and the disposition of the earnest money, now keep in mind that earnest money is sitting in a trust account somewhere, right? Okay. So if the buyer walks away and says, hey, man, I want my earnest money back, and the seller said, nope, not going to give it to you back, it could be a ridiculous dispute for that matter. But the fact of the matter is, in the event of a dispute, what we're going to talk about is what the agent or the firm is going to do. In the event of a dispute between the buyer and seller over the return or forfeiture of earnest money, the firm, if it's in the firm's trust account, the firm will hold the money in the trust account until one of these three things occur. And this is what we would historically test you on. Until we get written agreement of the parties. Now, this is actually very serious. If you ever have your own firm, if you're ever a broker in charge and a buyer calls you up and says, yeah, the seller and I agreed to split it down the middle, the earnest money, just send me my half and send them their half. Okay, I'll be glad to do that when you guys put it in writing. And trust me, we have forms for this. So it's written agreement of the parties. Once the parties agree, the buyer and seller agree how it's going to be dispersed, I will gladly disperse it that way from my trust account. Okay. But keep in mind, these are two parties that are mad at each other. So I doubt it's going to go that easy. Number two is if a court of competent jurisdiction tells me what to do with the earnest money, I'll do that. I'll obviously follow the court's orders. I don't love that one though, because that means somebody went after the other party for the money, and it involves some type of civil case. But if a court tells me to deliver it, I will. And then the other rule has to do with what you see down at the bottom, statute 93A-12. And here's what 93A-12 says. If I'm a firm holding money and there's a dispute, what I can do is I can give both parties 90 days notice. And I'd say, hey, buyer, hey, seller, you guys need to work it out. Because if you can't work it out within 90 days, then what I'm going to do is I'm going to turn it over to the clerk of court's office to special proceedings. And you guys are welcome to go fight it out there if you want to. So let me recap those three things that you can do. But keep in mind, this is only if there's a dispute. If there's no dispute, go ahead and release the money as is appropriate. If there is a dispute, I'm going to hold the money in the trust account until I get written agreement of the parties. A court of competent jurisdiction tells me what to do with it, or I give both parties 90 days notice and then turn it over to the clerk of court. The next paragraph here, that's written in all caps, it looks like it's an extraordinarily important paragraph. The reason you see things like this in a contract is because if it's embodied in a contract, it has to be set aside in such a way that it draws attention to itself. This draws attention to itself. So let me tell you what it says. In the license law chapter, we will talk about what happens in regards to trust accounts. There'll be three rules that we'll go over. Let me tell you what this particular rule is. If a firm has a trust account, they can put the funds in an interest-bearing account if they have the permission of the parties. So by putting it into the offer to purchase and contract, what I'm stating here is that my money, the earnest money might go into an interest-bearing account. And if it does, I'm telling you that we're going to use that for the firm's going to use that for the maintenance of the account. And all of this complies with rule, I think it's 93A6-12 or something like that. It's not important to know the rule number, but the reason it's in there is because it's actually not even a rule, it's a state law. But that's why you see that. We will deal with that more in license law. All right, the effective date of the contract. Let me remind you, this was capital E, capital D, effective date of the contract. And so what we're defining here is when it goes from being an offer acceptance to being a contract. This is a little bit difficult to read sometime, but let me tell you basically what it says. Before a contract has to be created, before a contract is created, there is an offer, there is an acceptance, but until it's communicated back to the other party, it is not in fact a contract. Now, let me tell you in the field why this is so important is when a buyer makes an offer, especially in the market that we're in right now in the triangle, and they are told by the listing agent, yep, we're going to take that. Well, the buyer starts acting as if they are going to win that. But keep in mind, until that seller has signed it, and that signing has been communicated back to the buyer, then they're not under contract yet. And think about what else could happen. The buyer might write an offer, the seller might counter offer. Well, if the seller counters, then what happens is the seller is basically creating a new offer, and then the buyer would have to accept it and communicate it back to the seller. So when all of those things happen, that's when we have the effective date of the contract. It's not when the offer is written. It's not even when it's signed, but it's when it's written, signed, and communicated back to the offering party. It's going to be highly important for test purposes. I told you I talked to you a little bit about due diligence, and there are 3 paragraphs that go together here. So I will brief those simultaneously. When we talk about due diligence, what does that mean? Well, basically what that means is that the buyer has a right to go in and do any investigations on the property that they want to, or not. I mean, they're under no obligation to do any. Diligent real estate agents clearly are going to recommend that buyers do these. Next, we talk about the due diligence fee. And remember, that was over on page 1. And a lot of buyers will come to you and say, well, I want to pay this much in due diligence fee. Well, it's fine. Whatever you want to pay, I'll be glad to make the offer. But keep in mind, you're not in a vacuum here. You are negotiating with another party, and the seller's looking at all the offers they're getting and how much due diligence fee. And that's why these due diligence fees have escalated so high in a triangle area. In a competitive buyer's market. It's a seller's market, but the buyers are competing against each other in this market. So the due diligence fee is a fee that is agreed upon by the buyer and the seller through negotiations. The due diligence fee will in fact go to, it'll be a credit for the buyer at closing. And the other thing about the due diligence fee is, look, buyer, if you want to walk away during the due diligence period, knock yourself out, walk away. You just lose your due diligence fee. But technically, the contract would argue you didn't lose your due diligence fee. You got what you paid for. You got the opportunity to do any investigations that you want to, and you tied the house up. And then look at the due diligence period. Completely negotiable. Notice that this is a blank here, but I want to point 2 things out to you. One is just kind of a subtle suggestion. The other one is very specific. My suggestion is make sure you give your buyer time to do the diligence necessary. In a busy market, it may take them a while to get inspectors, surveyors, appraisers out to the property. I think at the time I wrote this, I probably used 3 weeks. I usually try to use about 3 weeks for due diligence. That should give you sufficient time, but it's kind of based on market conditions and negotiations. The seller may say, nope, I'm only going to give you 10 days. Get in and out and figure out whether you're going to buy my house or not. If that's what it is, that's what it is. But 3 weeks is usually sufficient time to do your diligence and your repair negotiations, if any. The other thing I want to point out that's very specific about this is there are not that many places in the contract that are time is of the essence. However, the due diligence period is absolutely time is of the essence. So you'll notice there that on 8/31, at the time that I wrote this, at 5 o'clock on that particular date, my rights to terminate this contract under due diligence are over. I can terminate after due diligence if I want to, but after due diligence period, if I terminate, the earnest money is at risk. Okay. So it's important for buyers to understand, one, what did you get? for your $20,000 in this case? Well, you got the opportunity to do your investigations on the property. And if you close, it'll go as a credit. But you could also walk away during the due diligence period. If you walk away during the due diligence period, please listen closely. You will get your earnest money back, but you will never get your due diligence money back. Okay. So that is an extraordinarily important part for the test and also in the field. Again, with a little bit of indulgence here, let's go ahead and knock out the next 3 paragraphs as well, because it talks about settlement, settlement date, and closing. A couple of things you need to know here. Notice that I put a date in there, and I think the date I put was probably about 30 days from the time that I started this particular transaction, completely subject to negotiations. However, I will caution you, agents, make sure your buyer has enough time to close. If they're getting some type of exotic loan that takes a little more time, make sure you calculate that into the number of days you need to close. If you're closing around holidays, make sure you calculated that into the number of days that you need to close. Talk to the other professionals involved, such as the lender, attorneys, and stuff like that. Settlement is just a process. Settlement is when the attorney is bringing in all the paperwork. They're looking at over. The agents are providing information to the attorneys. The buyers and sellers are providing information to the attorneys in preparation for closing. The settlement date is the date we intend to close. And in this particular case, we want to close, we want to settle on 9/10, okay? And the place and time is typically going to be chosen by the buyer if you use this particular contract. Okay, so we define settlement, we define settlement date. Well, how is settlement date different from closing? Well, a lot of people say that they're going to a closing, but they're actually wrong. What they're going to is a settlement meeting where they sign all the paperwork and all that. But technically speaking, closing is defined as date and time of recordation of deed. Okay. So in other words, when you were at that settlement meeting, you signed all those documents and everybody shook hands and patted each other on the back. That's awesome. But you're not the owner of the property yet. It has not closed until it has been recorded in the new buyer's name. If it's been recorded in the new buyer's name, then the bank will release the funds and the seller will get paid and the buyer will get their keys. And then then the buyer owns it once the closing, the recordation has occurred. Please don't confuse the settlement date with closing, even though most often they happen on the same date. They are two different processes. Settlement is a process. Closing is the date and time of recordation of deed. Funds will not be dispersed until it has actually closed in most cases, and that's the way you'll be tested on it. Warning, technically speaking, you don't have to be an attorney to do a closing, but what we're doing in this contract right here is we're just flat out warning you, agents, look, to say that you could do a closing is not inaccurate. I mean, anybody could do a closing. The problem is there are legal acts that happen during a closing, such as going over a loan package. So if there are any legal acts that have to be performed, obviously you'd have to be an attorney to do that. My advice is, and I normally don't have a problem with this, is most agents do not get involved with the actual closing itself. They may be there to represent their client, but that would be the extent of it. Special assessments, we will talk about these a little bit later, but for right now, let me remind you again what a special assessment is. A special assessment is a charge against property by a governmental authority. Okay, could be a city, could be a county, could be a homeowners association. What you're going to see in this contract is fairly consistent. A special assessment is basically a one-time tax, if you look at it that way. And here's what the rule is going to be at the end of the day. When it comes to special assessments, if there's a special assessment on the property up to the time of closing, capital C closing, the seller pays for it. If it is a pending issue, then what happens is the buyer takes the property subject to any special assessments that come up after they purchase the property. You'll need to be very specific about that. It's not difficult, but you have to understand it. If that special assessment occurred any time prior to the closing, the seller is responsible, and they should know that when they're calculating their net to seller. And then, of course, any special assessment that's been proposed but has not been performed yet would become the obligation of the buyer, because he's now the owner of the property, and they would need to pay it. They can't go back against the seller if it was only proposed but not yet completed at the time that the buyer buys the property. So keep an eye on that. There's a couple of good paragraphs that describe the buyer and seller's responsibility. All right, fixtures. We had a whole chapter talking about fixtures. And we want to remind people here that yes, fixtures are important. Probably the first place that most agents mess up is in regards to fixture. So there's the definition of a fixture, an item that was once personal property that's become real by virtue of its attachment. If it's a fixture, it's going with the house unless you exclude it when you convey the property. Notice also that this paragraph will itemize in pretty good detail many, many things that are on AI property. Now, let me tell you 2 or 3 things just real quickly about that. If it's listed in this list right here, it is a fixture by definition. It is a fixture. But just because it's not on this list doesn't mean it can't be a fixture. If there's something that's physically and permanently attached to the house, it automatically becomes a fixture. And then there might be some of the things as you're looking at this list and you say, well, my house doesn't have a basketball goal. Why do I have to worry about that? Do I need to cross it out? No, you don't need to cross it out. The idea of this list right here is the following items, if any, convey with the property when it sells. So that's the way the fixture provision works. Fixtures show up in so many of the chapters that I'm not going to go into deep detail about these, but when you read this document, I would ask that you do read in detail some of the items that are already considered fixtures. Then, if there's something that the seller is planning on taking with them, there are a couple of paragraphs down here. D talks about items that the seller doesn't own. The seller can't convey something they don't own. And you usually run into this. You see some of the items that they list there. It could be satellite dishes, receivers, appliances, alarm systems. If the seller doesn't own it, they can't convey it. But agent, you probably need to tell the buyer what those items are. So they'll have a reasonable expectation. If they show up and the antenna's gone, they know why that was the case. And then when you look at E, it talks about other items that do not convey. If the seller is so attached to a fixture that's on the property and they want to exclude it, they could actually put that right here. If the seller's going to keep the chandelier in the dining room, then they could put it right here and let the buyer know that they're going to take that with them. Okay. If you don't do that, it's going to be considered to be a fixture and it's going to go with the property. Also, please note the note at the bottom of the fixture paragraph. If a seller does remove a fixture, even if it's by contract, they are responsible for repairing any damage caused by the removal of any of the items above, any of the fixtures above. Personal property paragraph works just the opposite. If there's personal property that the buyer wants, they should ask for it in this paragraph right here, provision 3. And notice the example I gave here, the refrigerator. There's no doubt that the refrigerator is probably the most common personal property that buyers ask for. The only thing I'm suggesting to you here is if you are in fact going to ask for it, be as specific as necessary. The refrigerator in the kitchen, as opposed to the nasty one out in the garage. And just to make sure the seller knows which one I'm talking about, it's the Whirlpool model number, whatever I put there, 43X85J. I don't know what that is. I just made it up. But what I'm identifying is the fact that make it as clear as possible what it is that you're asking for. Some other common things that you see in personal property, washers and dryers. I don't know, some other stuff occasionally, maybe furniture pops up. I would refer you back to your mentors in the field on this though, because you don't want to put too much personal property in there, especially if there's a loan involved, because the way the lender looks at it is the lender's loaning you money to buy a house. They're not loaning you money to buy refrigerators and washers and dryers. So it could get kicked out in underwriting if you're asking for too much personal property and it's really, really close deal. Okay. If you want personal property, ask for it. Okay. If you want to take a fixture with you, make sure you exclude it. Those are the way those paragraphs work. I would encourage you to read paragraph provision 4. Okay. I'm not going to do it. And here's why. A lot of times agents, when they're new, they will say, well, what should the buyer be doing during the due diligence process? Well, my hope for you is that you'll have a good mentor, a good checklist, or if you need to build your own, you could probably come to this paragraph right here, because what it tells the buyer is what they need to be doing during the due diligence period if they choose to. Do your inspections, review the documents. We've had cases recently where buyers bought in a subdivision thinking they were going to rent a house out. And what they ultimately found out was that they couldn't rent it out because the neighborhood didn't allow rentals. Well, they should have reviewed the documents before they bought the property. Insurance appraisals, et cetera, et cetera. Please read this list, not to memorize, but to give you an idea of what a checklist looks like of what a buyer should be doing during due diligence. Okay, let's go a little bit farther. Still in this paragraph, we're also asking the buyer, hey, do you need to sell another property to buy this particular property? And so we're trying to address that in this paragraph as well. And then certainly, are there any repair negotiations agreement? Let me tell you what this paragraph says, just so you'll be familiar with it. Buyer, you can do whatever due diligence you want to. And hey, look, you can ask the seller to fix anything that you all want to, but the seller is under no obligation to fix any of it. The best time for you to ask for this is probably during the due diligence period, because if you're not happy with the seller's answer and you want to walk away, you can limit your pain to only your due diligence fee. So that's what that's talking about. Next paragraph, it's fairly obvious what it says. Buyer's obligation to repair damage if the buyer or one of the buyer's agents, and when I say agents, I'm not talking about just the agent, I'm talking about inspectors, appraisers. If anybody working for the buyer harms the seller's property, the buyer agrees to indemnify the seller against loss on those. That's what these two paragraphs say. Buyer will repair the damage, and if buyer ends up being hurt while they're in the house, they would indemnify the seller against any damages there. Buyer's right to terminate. Very, very important paragraph here, because it goes back to what we were talking about in regards to due diligence. Let's make sure we have all the things we need to know about due diligence correctly. The due diligence money is due on the effective date of the contract. It's written to the seller. And what this paragraph right here says is, hey, buyer, you can terminate this contract anytime you want to for any reason or no reason at all during the due diligence period. You're just not getting your due diligence money back. But if you terminate during the due diligence period, you will get your earnest money back. If you terminate after due diligence, then you're going to lose both your due diligence and your earnest money. Please make sure for test purposes that you know every one of those scenarios and you can recognize them, okay? Getting into buyer representations here. Funds to complete the purchase price. Basically what we're asking here, hey buyer, how are you going to pay for the house? This is actually a material fact. Think about it. If you're selling your $400,000 house, you need to know that the buyer has the ability to come up with $400,000. You don't need to know they're a millionaire. That's irrelevant, okay? You need to know that they have $400,000 or can get it from a lender. So notice what we do here. If you're giving cash, the buyer just simply checks cash, and then verification of cash available for selling is attached. If I were you, buyer's agent, if I said that my buyer was paying cash, I would make the offer, but I would also have an attachment to that says that the usually a banker or financial advisor has said that this person has $400,000 in liquid funds to be able to buy this property. If they're getting a loan, then you're going to put the loan terms down here below. Okay. Notice that it gives you a check or places that you can check to tell what kind of loan it is. Now think about this for just a moment. The seller needs this information to determine if there are multiple offers, the integrity or the quality of the buyer. For example, if somebody's getting cash versus conventional versus FHA or VA. Now, FHA and VA are great loans, but if the buyer's getting it because they only have a modest amount of money for a down payment, they might not be as strong as a buyer who's putting up cash or conventional. The seller has a right to weigh that into their consideration. Okay, and that's where the buyer's agent lets them know how the buyer's going to pay for it. I haven't mentioned this, but notice at the bottom of every page, there is a spot for the buyers and sellers to initial it. This is not required by law for the contract to be binding, but oftentimes if you're working with a compliance office, they will make sure that these are initialed down at the bottom, or they might send it back to you for initials, because these initials at the bottom of the page are basically the buyer and seller saying that they have read this particular page and they understand that as well, okay? I mentioned this a little bit earlier. There's also a paragraph here that says other property. If in fact I am a buyer and I have to sell another property to buy this property, in fairness, the seller needs to know that information. In other words, again, the seller's looking at multiple potential buyers on this property. If he knows I have to sell the property in Roxborough to buy the property in Holly Springs, then he could use that to determine whether he would rather deal with me or whether he'd rather deal with someone who doesn't have a house to sell. This is very important, what I'm getting ready to say. So make sure you understand this. In North Carolina, our current contract does not include any contingencies, okay? There used to be contingencies for getting your loan. There used to be contingencies for the house appraising. There used to be a paragraph in here about if I had a house to sell like this, it would make it contingent, but none of these are contingencies today. If you want to make this contract contingent upon anything, you need to add that as an addendum and say, hey, seller, I will buy your house if the house appraises. I will buy your house if I can sell my house in Roxborough. Okay, there are no contingencies in this contract. If you're looking for a definition of contingency, a contingency provision just simply says this must be completed before the buyer is obligated to buy the house. This house must appraise at the sale price before the buyer is obligated. I have to be able to sell my house in Roxborough before I'm obligated. That would be an example of contingencies. Trust me, there are none in the contract as it is written right now, unless you add other documentation. There's a little more detail here. Again, I would encourage you to read this, especially in the field. You're clearly going to run into this because notice what the question was. Buyer, do you have to sell other property or not to buy my property? Yes, I have to sell that house. Okay, that's good information for me to know. And I want to know whether it's listed, whether it's under contract or whatever, so I can make an intelligent decision whether I want to be bound to you, buyer, or not. Okay, then you get into paragraphs down here about the performance of the buyer's financial obligations. Is there anything that would keep you, buyer, from performing your obligations? Please let us know now. All right, we're in the contract, but these issues came up in other chapters as well. The Residential Property and Owners Association Disclosure Statement, the RPOD, that's what I say most of the time. Notice the question that it's asking here. Check one of these boxes. The first box says that the buyer received it before writing the offer. It doesn't say what the seller answered. It just says that the buyer received it. The second box says that the buyer has not received it. And if the buyer does not receive the RPOD when it's supposed to be delivered, if the buyer hasn't received it by the time that they make an offer, the buyer will have a 3-day right of rescission. I would encourage you to read that paragraph to help you understand how the 3-day right of rescission works. It's actually extraordinarily complicated, but the worst case scenario would be 3 days after they go under contract, the buyer, if he never got the RPOD, he's just not entitled to it. Okay, it's not that he's not entitled, it's just that he's waived his right to it. Why do I mention that to you? The reason I mention that to you is I would love it in every case that that this is used, that the first box be checked. In other words, if a buyer made an offer with the second box checked, I would almost be tempted as the listing agent to send it back to them and say, hey, here's the RPOD, take a look at it, and then make your offer. Why would I go through those pains? To make sure that I don't give the buyer an unwarranted 3-day right of rescission, okay? Let me remind you a couple of things about the RPOD real quickly. I often say all sellers in the state of North Carolina are required to complete this form, with the exception of, most notably, new homes. New homes do not provide the RPOD. They're not obligated to provide that, okay? And then foreclosures are not obligated. There's actually a list of 8 exceptions to this, but the 2 notable ones are foreclosures and new homes do not have to provide the RPOD. If it's exempt, you see that third box down there, gives you a chance to check that and tell why it's exempt. There's also the mineral and oil and gas rights mandatory disclosure statement as well. It falls under the same law as the residential property disclosure statement does. However, it deals specifically with subsurface rights. There is a form for this, and it's basically the same thing. Buyer did receive a copy of it before they made the offer, or second box, no, they didn't receive a completed copy of it before they made the offer. You will act accordingly. However, let me remind you for test purposes that new homes are not exempt from the mineral, oil, and gas rights disclosure. Although new homes are exempt from the obligation of they are not exempt from the requirements of providing a mineral, oil, and gas rights. The other question I get a lot on this is people think that condominiums don't have to provide this since you don't own the land that you sit on. But condominiums are not exempt from the law unless they're, well, unless you end up buying a block of 5 of them. If you buy more than 4, technically they're exempt from the law because the law only applies to 1 to 4 unit dwellings. So anyway, back to my point on that, please note that new homes are not exempt from the mineral oil and gas rights disclosure. Get into buyer obligations here. Buyer obligations are kind of interesting because they talk about what the buyer has to do. And most of what they're talking about here is just simply telling the buyers of their responsibilities. For example, hey, buyer, look, if there are special assessments that are pending on this property or proposed on this property, you're going to take the property subject to those special assessments. The seller will take care of anyone's before closing, but anything after closing, you're going to take care of that. And also responsibility for certain costs. This talks a little bit about most of the things are involved with the loan or the buyer's diligence, but buyer, you are in fact responsible for those. Seller representations is exactly as you read it here. We're just asking the seller, will you disclose how long you've lived in this property? Has it been less than a year? Has it been more than a year? Weirdly enough, there's actually a category that says, I don't even own the property yet. Maybe I just have it tied up in some type of contract and I'm going to sell it before I actually close on it. So that's just asked and answered on that. Lead-based paint. It's been a while since we talked about lead-based paint, but let me remind you, any home that was built before 1978 should provide the lead-based paint disclosure unless they're certified lead-free. If they're certified lead-free, they could provide that form instead, but very, very few houses are certified lead-free if they were built before 78. There's an addendum for that. The parties would need to fill out the, complete the addendum, sign the addendum, and also the agents would actually sign the addendum as well. We're still in the offer to purchasing contract here. Owners associations and dues. Sellers authorize and direct any owners association management company to provide the following information. And so we give a list here of the things that the buyer's agent needs to research. If you're selling a home in Holly Glen, I think when I got to this point right here, I did not use accurate information. So if you're selling a home in Holly Glen, please don't use this information. I don't believe it to be correct. But as an example, Holly Glen Homeowners Association, and then the regular assessments are $165 per quarter, and then the management company there. Get all this information. Listing agent, please provide this, do the homework so that it's not a burden on the buyer and the buyer's agent to find this information very, very quickly. Then we get into the seller's obligations. I would encourage you to read through these, not to memorize, but just to be familiar with it. And it talks about the seller's obligation to be able to provide information that's ultimately going to help the buyer. It's going to facilitate the buyer closing on this property. If they have copies of title or surveys or deeds or things like that, provide them to the buyer. It will help facilitate the transaction. Authorization to disclose information, not a big deal. It's just the seller giving the authority to the attorneys to provide the appropriate information that the buyer needs to close. Access to property. Basically what it's saying here is, a lot of sellers think when they go under contract that they're done. Well, the fact of the matter is the buyer needs to be in that house to do diligence, right? And so this paragraph right here says that the seller will in fact provide access to the house. Now it says for reasonable, it says reasonable access. Okay. So the buyer shouldn't come in every day for a different thing, but I think it would be fair to be in there for home inspections, radon inspections, pest inspections, maybe even to measure for furniture or drapes or something like that. I think that would be reasonable. Okay. I would encourage buyers and buyers agents to schedule as many of these things on one day as possible. And then obviously for a final walkthrough to make sure that any repair negotiations have been taken care of. And then finally, the seller is obligated to keep utilities working through the time of closing. Why? So the buyer, if they are doing investigations, if they are checking on systems, they can do that literally right up to the time of closing. Paragraph D in seller obligations talks about removal of seller's property. You hope you don't have to say things like this to the seller, but hey, seller, by the time of closing, you need to have all of your personal property out. And by the way, please get rid of the garbage and debris as well. most of the time sellers are pretty good on this. Occasionally they're not. And there may be some stuff that's left over because in their haste, they left it. Ideally, seller removes all their property. Affidavit and indemnification agreement on this. There's one thing I'd like you to relate this back to. Earlier in the class, we talked about the concept of a mechanics lien. In a mechanics lien, do you remember that a lien could be filed up to 120 days after the last day of delivery of goods and services? And the lien priority would go all the way back to the first day of delivery of goods and services. So what's going on here is the seller is saying, look, I agree to indemnify the buyer against any work that's done within the last 120 days. Why? Because it might not show up on the public record. There may have been some time in there where it's not required to be recorded, but it would be a priority lien because it actually was, the work was done before the buyer was ever there. I love to have the seller's agreement to indemnify. Having said that, if you can't find the seller afterwards, or if they're bankrupt, have no money or whatever, now listen, that's what title insurance is for. But at least we're making the claim here to the seller. Hey, if the work's been done within the last 120 days prior to closing, can you prove to me that you paid for it? Or are you going to pay for it at closing? Or do you agree to indemnify the buyer if it comes back to haunt him after closing? Designation of a lien agent. Not a big deal there. If you do in fact have a lien agent in North Carolina, Mechanics Liens has a provision now where a lien agent can be appointed. I believe if the work is over $30,000, a third party lien agent who can kind of keep an eye on the transaction to make sure that everyone's content with the outcome. The seller agrees that they have good title, and notice this first blank right here, and make sure by the end of the class you know what all these words mean. The seller shall execute and deliver a general warranty deed, that's the greatest quality deed, for the property in recordable form no later than settlement, which shall convey fee simple, marketable, and insurance title. Again, the best assurance of title in this particular case, without exception for mechanics liens and free of any other liens encumbrances. Now watch this, watch where this sentence goes. Free of any other liens, encumbrance, or defects, including those which would be revealed by current and accurate survey, except ad valorem taxes for the current year, utility easements, and unviolated covenants, conditions, and restrictions, which do not materially affect the property. So notice in those two sentences right there, here's basically what it's saying. The seller saying, I'm giving you good title under a general warranty deed. If there's any problems with the title, come back and sue me because I told you it was good and you have a reasonable expectation of that, what we refer to as quiet enjoyment. Okay. However, there are some things that the seller can't promise you. There's always going to be the following on, but there's always going to be the potential for taxes. It doesn't mean there's a problem. It just means they haven't been billed and paid yet. So the seller agrees to take care of those at closing, at least for his share. They're utility easements. The fact of the matter is, if you're in a neighborhood, it's very possible that you might have a gas line, a water line, electrical line, a cable line across your property. And that's fine. That's for the betterment of the neighborhood. And then what was the other example that it gave? Oh, unviolated restrictive covenants. Clearly, restrictive covenants are a lien or an encumbrance on the property. But most people, when they're buying in neighborhoods, are aware of these encumbrances, and they need to be prepared to follow these. So they do exempt a few encumbrances on the property. And then finally, notice the last sentence there. The property must have legal access to a public right-of-way to make sure that you can get to a road so that you can go wherever you need to go. In other words, how are you getting to that road? Are you landlocked? Do you have an easement? Is there some right? The seller is actually guaranteeing you that you have legal right to a public access. If not, they might not be able to convey the property. In the notes here, I would like to go back and tell you that make sure anything that's in a box, read that, take it as serious. And if you have questions, please come to me and ask. This box here just simply, again, emphasizes the fact that buyers need to be doing surveys on these properties. That way they can uncover some of these potential issues and have the seller fix it while the seller still owns the property. In the deed, taxes and fees, basically what we're saying here is how we want the deed held. So on the first page, we talked about who's buying the property. The buyer doesn't necessarily have to be whose name the deed is in. It probably is 99% of the time. But if they wanted to buy the property for a child, or if they wanted to put it in a trust or something to that effect, in this particular case, I put the name of the trust that they're putting the property into. Okay. Agreement to pay the buyer's expenses. There's no obligation that there be anything here, but if the buyer negotiates some expenses to be paid by the seller, in markets in the past, it was not uncommon for the seller to pay part of the buyer's closing costs. Have today, our market is so hot for sellers that most of them say, no, I'm not going to pay any of your closing costs. If you can't afford to buy the house, I'll sell it to somebody else. But anyway, if the seller is paying some of the buyer's closing costs, you would put it there. Notice that it says include any FHA or vendor, lender, and VA lender and inspection costs. To give you an example of that, typically in a VA loan, the seller would pay the termite inspection, the would destroy an insect report. And if that's the case and it costs $125, I'd highly recommend that you put $125 in there to show that the seller is in fact paying it. The seller is also providing information about owners association fees and charges and helping confirm that information for the buyer. This is a material fact, so this should have all been disclosed to the buyer before they made the offer anyway. Payment of special assessments. Let me remind you one last time, if they are approved, if special assessments are approved prior to settlement, then they're the seller's responsibility. Notice that it also adds this, whether it's in a lump sum or future installments. Sometimes these special assessments are so large that they spread it out over 3 or 4 years. Well, if that's the case, if it was approved before settlement, the seller is responsible for it, whether it was a lump sum or whether he has to pay it over the course of 4 years. At closing, they would just go ahead and collect that money, so the buyer will not be burdened, because special assessments become a lien against the property. So the attorney is going to make sure that the seller doesn't leave a lien against the property for special assessments. Obviously, if there are late listing penalties for taxes, the seller should pay that. The buyer had nothing to do with that. And negotiated repairs improvements, even though the seller is not obligated to do any, if the seller agrees by contract to do these negotiated repairs, they should do them in a good and workmanlike manner, and they should do them prior to settlement so they can be verified by the buyer. When we get to paragraph 23, we will see what happens if the seller breaches this contract. Prorations and adjustments. There's going to be some math problems on the exam about this, but this paragraph right here tells you how the following things are prorated. Taxes, how we prorate real property taxes, personal property taxes, but only personal property only if it's conveying with the property, like a boat or something like that. Rents, how would they be prorated, and owner association dues. It just simply tells you how the prorations will be done. If there's a home warranty here, then it'll tell how it's going to be paid for. The first box says there is no home warranty provided by the seller. The next two boxes say the buyer may obtain one, but the seller's going to pay for it. And the third one says the seller has obtained and paid for a homeowner's. You will know that that is transaction dependent. So you'll know what it is for your particular transaction at the time you write the offer. Risk of loss and condition of property at closing. Let's hit this on a high level. And here's what the high level on this says. Up until the time of closing, the seller is responsible for any risk of loss. If the house caught fire, was blown over by a hurricane or whatever, up until the time of closing, the seller is responsible for that. Okay. After that, the buyer is obviously responsible. You say that, well, that doesn't sound like a big deal. Where are you going with this thought? Well, keep in mind, one of the big deals today is that sellers are often receiving the right to possess the property even after they've closed on the property, because they need some time to close on the house that they're buying. So think about this. If a seller sells a property and it closes on August 31st, closing is August 31st, but the seller is going to stay in there until October 1st, 30 days or so. Okay. So they close on August 31st and they're not going to move out until October 1st. Well, the fact of the matter is the buyer now owns the property, and the buyer is the one who needs to have the homeowner's insurance. The seller, who is now just a tenant, would need to have some type of tenant insurance policy for their personal property. So the risk of loss, it makes a lot of sense. Up until closing, the risk of loss is the seller's, and then after closing, the buyer takes it. Watch out for possessions other than closing, okay? And then finally, the condition of the property at closing. The property should be in the same condition at closing that it was at the time of the contract. The seller needs to make sure they keep the property in roughly the same condition, or better for that matter, than it was at the time that they went under contract. Next paragraph, very important actually. So let me slow down on this. In regards to delay in settlement, let me remind you this. On the first couple of pages, we put a settlement date in there, the date that we planned on settling. And that was a good faith effort to determine when the buyer was going to settle. Having said that, there are always things that could come up. Sometimes the lender asks for one more document at the last minute, and it delays closing. Maybe the buyer could not get in time for their final inspections or things like that, and they need to delay the closing. Maybe someone's sick and can't go to close. Anyway, here's what this paragraph says. Look, if you're making a good faith effort to settle and you're delayed, according to this contract, you have 7 days right in a good faith period to get your act together and close. But let me tell you something, buyer. After the end of that 7 days, if you can't close, then on the 8th day, the seller could actually kick you out of the contract, and they could keep all the money that you've paid so far, because in essence, the buyer is in breach at that point. This paragraph actually works both ways. And here's what I mean by that. There are some times when the seller is actually potentially in breach. If they're struggling to clear title, if there's a defect on the title that came up during the survey and they can't clear it during those 7 days, technically speaking, the buyer could terminate and ask for all their money back, because the seller would be in breach at that point. What do I want you to remember about delay in settlement? Look, this is a 7-day good faith period that if you were not able to get it closed on time, it gives you a little bit of time to get your act together. Agents need to take that into consideration when they are when they're working with buyers and sellers, for that matter, to make sure there's enough time that they're going to be able to get this done in a timely manner. I mentioned possession just a little bit earlier, and here's what I'll say about possession. Ideally, possession should occur at closing. The change of possession should occur at closing. That's the standard for our contract. In other words, at closing, the buyer now owns it, the seller is now gone. Okay. However, we have forms if something other than that needs to happen. If the buyer wants to possess the property before closing and is able to negotiate this, then we have a form for that. Why would a buyer ever need to be in a house before closing? Maybe their apartment lease ran out. It's a week before closing and they want to be in so they don't have to go rent a short-term apartment. I get it. I don't recommend it, but I get it. Okay. We have a form for that. Seller possession after closing is attached. This is actually very, very common today. Okay. The sellers need extra time after selling their house to find or to occupy the property that they're under contract on. And then the possession is subject to rights of tenants. Let me remind you, if there is a contract between a buyer and a seller on a house that has tenants in it, the buyer takes possession of that property subject to the tenant's rights. If they have 6 months left on a year lease, the buyer takes the property knowing that he has to allow that tenant to be in there for the next 6 months, unless the tenant agrees otherwise, or if the tenant breaches the lease and ends up being evicted. But you cannot evict a tenant in good standing just because you bought it and you want to move into the house. On this particular paragraph right here, when it talks about the addenda, one of the cautions that we often talk about with our agents is please do not draft your own provisions. If you need wording that is not in the offer to purchase and contract, look first to see if there is a form that'll take care of that. For example, the first form, the additional provisions addendum, the most common use of that form is in the opening provision. It actually has a place that says, as the buyer, I'm making this offer and it's going to be good until Sunday at 5 o'clock or something like that. That's not in the standard offer to purchase. So we use an addendum for that purpose. There's some other things in the additional provisions addendum as well. So here's what my point is. Agents do not draft contracts. Okay. That's against the law, literally, for agents to draft contracts for others unless they also happen to be an attorney. All right. We have really good forms for these addenda. And then if there's something that's not anticipated by any of these addenda, go to an attorney and have them draft one for you. And you can see, you can put it here where I have not applicable. If you had an attorney drafted form, you could literally put it in that and say, see attached attorney drafted addenda, addendum, and attach that to the body of the contract. Assignments, I don't want to go into deep detail about paragraphs 15 and 16, except to relate it back to a definition that we talked about in class. All contracts are assignable unless the contract says otherwise. So if you look and you read those two paragraphs right there, it gives you a couple of examples of when this one can be assigned. This contract actually says it cannot be assigned unless you have the agreement of all parties involved. So technically it can be assigned, but only if you have the written agreement of all parties involved. The other time an assignment comes up is in a tax deferred exchange, a 1031 tax deferred exchange. There's a technical assignment that has to be done, and we accept that as agents and parties. The parties to this contract, let's turn this into a test question just real quickly. The parties to this contract are the buyer and seller, their heirs and successors. Okay. Now let's think about why that's important. Throughout our class, we talked about what happens if someone dies during a transaction. Well, here's the deal. If your seller died before this was under contract, it would actually terminate the listing agreement, okay? Because listing agreements are personal services agreements. And so if the seller dies, then there's no one there to work with. On the other hand, if it's the offer to purchase and contract, the buyer and the seller are in fact parties to this contract. And if either party dies, realistically, let's talk about it on the seller side. If the seller dies, the seller's heirs would be obligated to complete the transaction. Okay, literally to the extent that if they said, no, we want to keep grandpa's house, the buyer could sue them for specific performance, but only if it's under contract at the time that the seller dies. Okay, please note the difference there between the way agency agreements work and the way the offer to purchase and contract works. A lot of people ask me and say, well, what if the buyer dies? Well, what happens if the buyer dies is they're typically going to be in breach because they're not able to complete the transaction. So if the buyer dies, that's tragic, obviously. But the fact is, they're probably going to lose their due diligence and maybe their earnest money as well, unless one of their heirs steps up and takes over their role in the contract. But you can't make an heir step up and buy something. The worst case scenario is the buyer would be in breach and the penalties of breach would ensue. Survival. Hey, look, this is the contract here. If you want something to survive this contract, then you need to have it in writing and agreed upon by the parties. If you want somebody to come in after closing and do some work paid for by the seller, you need to have that written in a document signed by both parties, and then it will survive this agreement. But otherwise, closing, everything's over. This is the entire agreement. No spoken agreement is going to interrupt. This is what we refer to as a merger clause when we talk about the entire agreement. So if you had any negotiations that were strictly verbal that are not memorialized in this contract, then they're not going to be binding except at will. I mean, if the parties do it, it's fine, but they would not be obligated to do it. It would not be enforceable. If you want it to happen, it needs to be in this document right here or an addendum attached thereto. Okay. Conduct of the transaction says a lot of stuff about how we're going to handle and how we're going to handle communications. However, let me tell you the important thing that this paragraph says. The important thing that this paragraph says is that when I am talking to the agent of the buyer, it's the same as if I'm talking to the buyer. Now, let me tell you why that's important. The reason that's important is any notice of communication can be given to a party or to such party's agent. So if the buyer makes me an offer in writing, my seller signs it in writing, okay, and I'm the listing agent, I can call up the buyer's agent and say, congratulations, we are under contract. So let's take a look and see what happened. We had a written offer. We had a signed acceptance. But remember from the previous, from the very start of the contract, we talked about the effective date being the date an offer is made, received, and communicated. When I pick up the phone and call the buyer's agent and communicate with them that my seller has signed acceptance of the contract, bam, we're under contract that quickly. The buyer might not even know yet, but it doesn't matter because I spoke to his agent. Very important concept. Execution paragraph, not extraordinarily important these days. Computation of times, of dates and times. I need you to know something very succinctly about this, and it is this. In this contract, a day is a day. It's a calendar day. It doesn't matter if it's Saturday, Sunday, a holiday, or whatever. It's counted as a day. There's only one spot in this contract where it mentions anything other than a calendar day. And if you would go back over to the top of page 2 of this contract, you'll see that it mentions the word banking day in relation to delayed due diligence fees. If the buyer's late with the due diligence or earnest money fee, the remedy for that has to occur within one banking day. But that's the only time you'll see one banking day appear in this contract. The remedies paragraphs talk about things that actually, if you'll let your mind relax a little bit, you're going to do very, very well on this part. What happens in the event of a breach by buyer? Well, logically speaking, if a buyer changes his mind, decides to not complete the contract or can't complete the contract, he's going to be in breach. Well, what this paragraph does is defines what a breach, the penalty for breach is. And if you look on that third line there, you will see that in the event of a breach by the buyer, the damages will be liquidated at the earnest money. In other words, what happens if the buyer breaches? He loses his earnest money as liquidated damages. And here's what that term means. Liquidated damages means all you're getting is the earnest money. Okay, don't come after me for anything else. You agreed that in the event of a breach, that you would accept my earnest money as the penalty for that. It says technically it's not a penalty. It's not meant to be punitive. It's meant to be, it's meant to pay the other party for the breach. So what do I want you to remember out of this paragraph? In the event of a breach by the buyer, the damages will be liquidated at the earnest money. Seller, don't bother trying to get more than that according to this contract. Now, what happens if the seller breaches? There's actually a couple of remedies here on the buyer side. If the seller breaches, just changes his mind, technically the buyer could sue him for what's known as specific performance. Please seek your notes or an attorney. If this happens in the field, obviously you got to talk to an attorney about it. But specific performance means, no, seller, after you go into contract, you can't change your mind. If I have to get the courts to do it, I'm going to make them I'm going to have them make you sell me the property under the terms we agreed to. In other words, the courts won't make the seller give you the property. They'll just simply force the seller to sell it at the terms that they agreed to. The other remedy in the event of a breach by the seller is, and most of the time when the seller breaches, it's not because they changed their mind. Most of the time when a seller breaches, it's because they can't deliver clear title or something like that. If the seller breaches in that particular case, what's going to happen is that the buyer is going to be entitled to compensatory damages. Compensatory damages is a very important word. Compensatory damages means this: however the buyer was harmed, they need to be compensated for that. So I ask this question in class a lot of time, and people say, well, if the seller breaches, the buyer gets the earnest money and due diligence money back. That is in fact true, but that's not much of a penalty. That was the buyer's money to start with. But what it further says is that if the seller breaches, he needs to reimburse the seller for all the money that he spent in an effort to acquire the house. For example, the buyer would have spent money applying for a loan, an appraisal, a survey, inspections, et cetera, et cetera. The seller should compensate the buyer if they were to breach the contract. So what paragraph 23 does is it talks about what's going to happen in the event of a breach by either party. I would like you to be familiar with the word liquidated damages and how that applies, and compensatory damages and how that applies to a breach by the seller. In North Carolina, it's possible that if you take the other party to court and win, you might be entitled to some attorney's fees. Don't get excited though. Please talk to your attorney to find out what the limits are on an attorney's fees. But this paragraph right here just simply says, hey, look, if you're the losing party, you might end up having to pay some of the other guy's attorney's fees. So think twice before you go to court. And then finally, as we get to the last page here, just a couple of legal notices on this page. People always ask me about this paragraph that says the Bar Association makes no representation as to legal validity or adequacy of any of the provisions in this form. So students always ask me and say, well, golly, are they saying that this is not adequate? Here's the problem. This is a very, very good form. What the attorneys and the Bar Association doesn't know is if you're going to use it correctly. In other words, this form was for buying houses or condos, townhouses, or things like that. If you were to try to modify this form to buy a commercial building or vacant land, you'd be using the wrong form. And so that's what they're actually disclaiming here, that they can't guarantee that you're always going to use it correctly. Okay, so don't worry too much about that. And then as you look at this page, you can see I signed it as the one who made the offer. I did not have the buyer sign it in this particular case. You'd have to assume that this was a counter offer since the seller signed it first. But the other party would, of course, sign it, signed by both parties and communicated back to the offering party. Bam, we're under contract. And then, of course, as we go a little bit farther to the next page, the notice information of the agents is on this page, currently page 14, if I remember correctly. Yeah, currently page 14. And basically what this does is it resolves the required notices that we have to give by real estate commission rule. In other words, as you look at this, you can tell that the buyer had an agent, the seller had an agent, there is no dual agency involved, and this is how you reach the parties if you need them. I would like to refer you back real quickly, and I had suggested to you that you read everything that is in these boxes. Extraordinarily important in the field to help your clients understand how significant wire fraud is in real estate transactions. There's so many communications, and a lot of them have to do with money and closing dates and stuff like that, that hackers are actually able to put together a real estate transaction, make it look like they're involved, request a wire, and it's very simple for your buyers to fall into a trap where they end up wiring funds to a bad actor on this. So anyway, multiple times in the agency agreements, in the offer to purchase contract, and most agents actually have it in their tagline on their emails as well, the do not wire. I'm not going to, me as an agent, I am not going to get involved in wire instructions, and I highly recommend that to be the case. The final page of the offer to purchase contract is just basically a receipt page, page 15. You'll often hear it referred to in the field. And this is if someone delivers due diligence money. And matter of fact, here's my advice to you. If you ever hand a check or money order or whatever to another person, you need to document that you handed that to someone. So if I'm a buyer's agent and I act as a custodian of the due diligence fee and I deliver it to the listing agent, when I hand it to them, I'm going to have them sign that they received it. Therefore, I'm no longer responsible for it, and I have a paper trail showing who is now responsible for it. So with that being said, we have completed the first offer to purchase and contract. A lot of good information on this, a lot of complicated information the first time you go over it. So please be sympathetic with the fact that buyers and sellers, they may not know every term of this contract. And so my request to you is, as you're looking through this, if you don't understand a provision, please come to me and let me sit down with you and say, okay, this is important, or it's not important, or it's only important in this particular case, or why we're even asking this question to start with. Okay, that's the standard offer to purchasing contract, most likely used for single family homes, condos, townhouses, up to 4-unit dwellings is probably going to be the best.